charged with a second-degree felony offense of aggravated assault with a deadly weapon, or with a weapon, April 16, 2023. It's a knife.
Firearm was used.
Oh, and a firearm. There's two paragraphs. One is exhibited a deadly weapon, a firearm, and one was a knife. So both. And Mr. Rennick is here, and we reset this to today so that we could have witness on an application for writ of habeas corpus seeking bail reduction. Current bond is set at $250,000. Mr. Rennick, you may proceed.
Thank you.
Yes, sir.
Could you please state your full name for the record?
Tammy Chanel Engel.
And how are you employed, sir?
I'm a police officer for the city of Florida.
How long have you been employed as a police officer with Plead?
7 years.
And I don't need the address, but please tell the judge what city, state you reside in.
Florida, Texas.
Okay. And, do you know the defendant, Shay Allen Merchant?
Yes.
Because once of them identified by the article code.
Anyone should.
You are not asking the record reflect the witnesses identified the defendant.
The record will so reflect.
How do you know Shay Allen Merchant?
We were boyfriend and girlfriend.
How long did the two of you date?
Almost 2 years.
And did the two of you cohabitate?
Yes.
And were you cohabitating back in April of 2023?
Yes.
And on April the 16th, what, if anything, transpired between the two of you?
He called me from the living room while I was in the bedroom and demanded that I go get him a can of snuff. I declined and hung the phone up on him. He got angry. He called me back. I got out of bed. I gave him $20, told him to get it himself. He told me he was going to start breaking stuff if I didn't go do it. So I got up and I went and did it. When I got back, he had damaged my patrol car and was throwing, I made custom tumblers, and he was throwing them in the driveway so that way I could not pull fully into the driveway. He met me in the driveway with a gun, which he put to the my left head right here, and forced me inside the residence.
Isn't it true that he actually dragged you into the residence?
Yes, he had grabbed me by my arm.
How did you get into the residence?
He had grabbed me by my arm and forced me into the garage, which he shut it, making me leave all of my purse and belongings in my car, and told me that the oak sale got stolen.
Once you got into the residence, did he put his hands on you?
He had told me that I needed to take myself to bed, so I went and lay down in bed, and that's when he had gotten a knife out, and he had placed the knife against my neck, causing a small abrasion.
Before the first witness even takes the stand, this judge makes something very clear. He is watching everything. Not just the testimony, not just the allegations, but the defendant's posture, facial expressions, and attitude. That matters, especially in a bond reduction hearing involving violent felony charges. This isn't a minor case. The defendant is charged with second-degree felony aggravated assault involving not one, but two deadly weapons, a firearm and a knife. The bond is set at $250,000, and the defense is asking the court to reduce it. But bond hearings aren't about sympathy. They're about risk. Risk to the victim, risk to the public, risk of future violence. And as this hearing unfolds, the court is about to hear allegations that go far beyond a single bad night. Threats, prior abuse, protective order violations, and chilling details that suggest a pattern, not an isolated incident. By the time this is over, the question won't be whether the bond should be lowered, it'll be whether the current bond is enough.
Did he choke at some point?
And then he had walked out, so I had went into the bathroom. He had then floored me into the bathroom and choked me several times in the bathroom, picking me up by my throat and throwing me against the windowsill, bruising my back.
Did he at some point punch you with a closed fist?
Yes.
Did he bite you?
Yes, he bit me on my nose.
showing you what's been previously marked as State's Exhibit number 1. Do you recognize this?
Yes,
What do you recognize it to be?
those are the marks this is from the knife and this is from him choking me.
Is this a fair and accurate depiction of how your neck appeared on the day of the incident?
Yes,
Your Honor, at this time, I'd offer State's warrant out for purposes of record opinion.
No objection.
It's admitted.
Was this did you require medical treatment?
yes, I went to the hospital.
Okay. Did you flee the residence?
After I had told him what he wanted to hear, so he calmed down, I was able to leave the residence, and that was when I called the police department.
You called your own department,
Yes,
made a report with PAPD,
yes,
showing you what's been marked as State's Exhibit number 2. Do you recognize that?
yes, it's the firearm he put to my head.
It's a fair and accurate depiction of the firearm that day.
Yes,
At this time, I'd offer State's 2, for purposes of record opinion, to defense counsel for this inspection.
No objection.
It's admitted.
Did you give PAPD a written statement reflecting what you testified here to today?
yes,
Was this the first, was this the only incident of violence between the two of you?
no,
And I want to interrupt you here. We're not here to have a full-blown trial, but I'm asking you to give the judge at least a picture, an idea of the nature of the relationship. So this wasn't the only time.
no, this is not the only time.
Please briefly give the judge an idea of any past incidents.
There had been instances when I had caught him cheating, and then he had been physically abusive towards me by punching me. He had bit my ear and my forehead back in October. Then also 2 or 3 days prior to the 16th, when all of this took place, he had, while I was laying in bed, taken a knife and like cut the bed around and poked holes in the mattress above my head, making threats to harm me.
Did he carve anything in the walls of your residence?
Yes,
Objection leading.
Overruled.
What did he do?
he had poked several holes in the wall and in the bed, and he also carved F, the N word, into my bedroom wall.
Let's go back to April 16th of 2023. I neglected to ask you about, was it an incident involving his blood?
Yes, he also, during that whole incident, had cut himself on his arm like twice with my duty knife, and then was smearing his blood all over me. And then he also took that knife and he cut my hair.
Has CPS been involved with the two of you?
Yes, he, on Wednesday prior to the incident, tried to sick our pit bull dogs on CPS, which is what, so when I got home from placing my kid after CPS took my kid, I had told him to get out of the residence, and then that's when the violent behavior progressed until the Sunday.
Around this time, did he send you some text messages?
Yes, he had sent me several text messages while I was visiting my child.
Again, briefly give the judge some idea of the nature of those text messages.
That he should have threatened, he should have slit my throat, that he was gonna kill me.
Is it fair to say they were profane?
Yes,
Is it fair to say that they threatened you in a number of ways?
absolutely. He also threatened to harm my brother and sister-in-law who I was with, which is who I placed my son with after he had gotten CPS taken.
This is the heart of the hearing, and it's devastating. The witness isn't speculating. She's describing a sequence of events that escalates rapidly from verbal control to physical terror. A firearm pressed to her head, being dragged back into the home, a knife held against her neck, choking, punching, biting, and threats that didn't stop even after the incident ended. What makes this testimony especially powerful is detail. Judges listen for consistency, chronology, and physical corroboration, and this witness provides all three: hospital treatment, photographs, a written police report, and descriptions of injuries that match the alleged weapons. This isn't vague fear. This is specific, documented harm. Even more concerning for the court is the context: prior incidents, escalating behavior, threats to children, and acts designed to intimidate, like carving threats into walls and damaging property. For bond purposes, this paints a very clear picture. Someone capable of extreme violence who allegedly uses fear as control. That's exactly what bond is meant to guard against.
Did you provide those text messages to law enforcement?
Yes,
You understand why we're here today, correct?
yes,
This defendant seeking to lower his $250,000 bond, correct?
yes.
What do you want this judge to know? Well, first of all, how did those text messages and the incident back on April the 16th of 2023 make you feel?
I was scared for my life.
And if this defendant were to get out of jail or be released on a reduced bond, what, if any, concerns do you have?
I fear for my life. If he gets out of jail, I have a 5-year protective order. He has sent me letters from the jail. He has tried to email me
I'm
from
sorry,
the jail.
but since the
Protective order's been in place, he has mailed me 2 letters from the jail and tried to email me from the jail email since the protective order's been in place.
So sir, say he's violated the terms of the protection,
Yes,
even while he's in custody.
yes.
Is there anything else that you think this judge needs to know before she makes her decision about whether or not to release this or reduce this?
I just strongly fear for my life that he is going to retaliate against me. He made threats to harm both of my kids, even during the incident, and I'm scared.
That's all I have, Judge. I'll pass the witness.
Any questions, Mr.
Yes,
Rennick?
just a few. Ma'am, a few questions. Other than this incident in which you contacted the authorities, how many other times have you called the police related to alleged violence?
I haven't called the police.
So this is the first time you've ever called the police. Is that fair?
That's fair.
Okay. And at your residence, who resides at your residence at this time other than yourself and Mr. Merchant?
Mr. Merchant's been evicted from the residence.
Right, prior to that time.
It's me and my kids.
Okay, anyone else?
No.
Okay. And is it also true that after this happened, did you yourself start calling other bonds companies and informing them?
No, I did not.
Did your ex-husband call bond companies and start making comments about Mr. Merchant?
He may have, but I did not.
Okay. You understand you're under oath, correct?
Yes,
Are you aware of your husband calling bond
it's not,
companies?
it's my ex-husband.
Your ex-husband calling
Yes,
bond
I'm aware
companies?
that that's what he did.
So when you said you were aware, maybe you did, maybe you did not, that was not a truthful statement, was it? You are aware that your ex-husband was calling around town to different bond companies and making negative comments about Mr. Merchant, correct?
Yes.
So why did you not answer truthfully to my first question?
I don't know that I didn't answer truthfully.
I'll pass it on. My questions, please.
I have no further questions from single John.
Thank you, ma'am. You can have a seat or step.
2 other short witnesses.
All right.
I called Michael at this time.
Michael Engel.
That's right. How do you know Tammy Engel?
She is the mother of my youngest son, as well as we were married for 15 years.
And when did you say were married? When did the 2 of you divorce?
The exact date, I couldn't tell you, sir, approximately 4 years ago.
And do you recognize the individual here in the orange jumpsuit?
Yes, I do.
Who do you know him to be?
Shay Allen Merchant.
And let's just cut to the chase. What has been the nature of your involvement or interaction with Shay Merchant?
It has been very stressful and threats provided by Mr. Merchant.
Threats directed toward
Directly towards myself and my 9-year-old son.
and back on December the 10th of 2021, did you have an occasion to speak with the defendant on the telephone?
Yes, sir. I received a phone call approximately 5:30 to 6 a.m. In the morning.
And during that phone conversation, what, if anything, did he say to you?
During the original phone call conversation, there was several threats provided to myself by Mr. Merchant.
And after that initial call from him, did you call? Did you call anyone?
Yes, sir. Once the phone call disconnected, I turned around and called my ex-wife to inform her of what was taking place.
Did she answer the phone?
No, sir, she did not.
Who answered the phone?
Shay Merchant answered the phone.
And how did that call go?
Started by yelling, screaming, and threats by Mr. Merchant with continuous threats, not only towards myself as well as towards my 9-year-old son.
Was that, did you record that phone call?
Yes, sir, I did.
I'm handing you what's been marked State's Exhibit number 3. Do you recognize that?
Yes, sir, I do. It's the
This is where the defense tries to poke holes, but instead highlights something worse. Despite a 5-year protective order, the defendant allegedly continues contact from jail, letters, emails, indirect communication, and from a legal standpoint, that is enormous. Courts take protective orders seriously, especially when violations happen while the defendant is already incarcerated. Then comes the credibility test, under oath, direct questioning, bond company calls. The judge isn't focused on technicalities, he's assessing honesty. And honesty matters more than anything else in hearings like this. When answers become hesitant, unclear, or defensive, judges notice. But the most damaging part isn't confusion, it's persistence. The testimony shows that even confinement hasn't stopped the defendant from attempting contact. That signals disregard for court authority, disregard for victim safety, and disregard for consequences. From a judge's perspective, that's not someone ready for release. That's someone who poses a continued risk, regardless of bond conditions.
CD that has the recording on it.
The recorded phone call from December the 10th of 2021 between you and the defendant.
Yes, sir, that is correct.
You've listened to this recording. Is it a fair and accurate recording?
Yes, sir, it's very accurate.
Made by a device, your cell phone, that was capable of making an accurate recording?
Yes, sir, that is correct.
And you certainly knew how to properly operate your cell phone, correct?
Yes, sir.
Now, at this time, I'd offer States 3.
I'm going to object that has not been provided to the defense. We have requested discovery and we have not received any recordings from the state. So we reset this hearing to provide Mr. Cole the opportunity to bring witnesses forward, and objecting to him presenting an audio recording, something that has not been provided to us and we've not had the opportunity to review.
Judge, I only received this recording within the last day or so.
Okay.
That's fine. So, well, and the testimony as far as what kind of went on back then, I'll take that, but I'll sustain the objection.
During the phone call, did the defendant make derogatory statements about you or your family members?
Yes, sir. Against myself as well as my 9-year-old son.
What did he call your 9-year-old?
He called my 9-year-old son retarded.
Did he threaten to kill you?
Yes, sir.
Was this the only instance of any threats or harassment by this defendant directed toward you?
No, sir. The following Saturday, when I met Tammy to pick up my son in the Hobby Lobby parking lot, Mr. Merchant got out of the vehicle and started to attack me. Tammy and a law enforcement officer had to pull him off of me.
Did you file charges as it relates with the law enforcement as it relates to the threats that were made on the phone call?
Yes, sir, I did.
Ultimately, did you file what's referred to as a non-prosecution affidavit?
Yes, sir, I did.
Why did you do that?
I did that after talking with Tammy and her expressing the stress and hardship that it was putting on her household, as well as the stress on my 9-year-old son and that household. I felt that to relieve the stress and the tension and violence within that household, to drop the prosecution of it, hoping that it would help relieve the situation that was within the household.
And the fact that you filed that non-prosecution affidavit doesn't in any way negate or indicate that what you testified to that had transpired actually.
That is correct. That is correct, sir.
Are you concerned about the safety of your? Are you concerned?
Yes, sir. I'm very concerned. Not only am I concerned for Tammy, as well as my 9-year-old son and my 18-year-old stepson that lives in the household.
And you understand we're here today on the bond reduction The defense counsel is asking the judge to consider lowering this defendant's $250,000 bond. What would you like for the judge to consider or know in that regard?
I would like you to know the fact that since Mr. Merchant has been locked up, there has been several threats exchanged, as well as violation of the protective order for my two boys, as well as Tammy, by not only literature communication, phone communication, as well as communication from family members that he has had to contact my ex-wife. The mail correspondence is still taking place, and it violates the 5-year protective order that the judge has signed and put in place.
That's all I have, Judge.
All right, Mr.
So just a few questions. First of all, you have expressed to the court that you have concerns about your safety related to Mr. Merchant, correct?
That is correct.
Of course, you also testified to that he allegedly committed a crime.
In the end, the judge explains exactly why the bond will not be reduced, and it's not just the testimony, it's the totality of the evidence, the seriousness of the charges, the alleged use of deadly weapons, the pattern of violent behavior, the ongoing violations of a protective order, and yes, the defendant's demeanor in court. Judges are human, but they're trained observers, and when behavior aligns with the allegations, that matters. The court makes it clear public safety is a primary factor in bond decisions. A 6-figure bond in a case like this is not unreasonable, it's necessary. This ruling isn't punishment, it's prevention. Cases like this are a reminder that bond hearings are not technical formalities, they're life and death evaluations of risk.
Against you, correct?
That is correct.
And you also informed the court that you were so concerned you filed an affidavit of non-prosecution. Is that correct?
That is correct.
Okay. And you've also taken upon yourself to contact various bond companies and things of that nature, basically to slander my client. Is that correct?
Contacting, correct. Slander? No, sir.
Were you calling to talk about what a wonderful human being was when you called him?
I was calling to prevent him from bombing another jail.
Okay, so my question is, so you were calling basically to defame my client, to slander his name to various bond companies that did not contact you. Is that correct?
Sir, slander is stating something that is not correct. I stated what is correct.
If we're going to play semantics thing, I can do that all day.
All right, no, we're not going to go there. Just, he's answered the question.
Okay.
Ask another question.
All right, I'll pass the witness.
All
I
right.
have nothing further for this witness, Your Honor.
All right. Thank you, sir, for coming. You can sit
Thank you,
down.
Judge.
Your Honor, I briefly called Troy Robinson to the stand.
All right, Mr. Robinson.
Of someone with at a minimum anger issues and at most issues with violence. We also have the ingredient of some very serious allegations here. Brandishing a firearm, holding a knife to someone's throat and threatening to kill them. And lastly, the last ingredient of this is, Judge, we've got a defendant who, even from the jail with a pending protective order, is violating that order. He's demonstrated a lack of respect for the law, a lack of respect for court order. Judge, all those ingredients, they are a recipe for something tragic to happen. And this court, under the Code of Criminal Procedure, can consider the public safety is one of those factors in setting a reasonable bond. And the state's position is that a 6-figure bond in this case is not unreasonable. We'd ask that the court deny the defense motion to decrease or to reduce the defendant's bond for those reasons, Your Honor. Thank you.
Anything else?
No, Your Honor.
So based on all of the evidence that was presented today, as well as, I don't know if everybody, y'all all know me and y'all know what I do during these hearings, and I typically keep my eyes on the defendant, the facial expressions, the attitude of Mr. Merchant, I believe is absolutely in line with what Mr. Coleman has said. I'm going to deny that writ or deny that. The bond, I think, is appropriate at what it's set at. We'll get this set for an announcement and we'll see where the case goes. Thank you. Y'all are excused. Was this on a writ to you? Okay.